Then I believe, Your Honor, both the ICSID and ICC tribunals will take its bearings from there. Because after all, it is the Philippine law on expropriation that governs. Now, the main question in investment disputes is whether there has been an expropriation. The ICSID has never, as far as I know, has never entertained corruption as a defense. There has been no case in the ICSID where corruption was a defense successfully pleaded to excuse a claim. I was just told 1 hour ago that there might be one recent case where it was entertained, but in that case, the government did not expropriate. The government did not concede that it expropriated. So if the government, on the one hand, pleads expropriation, and then on the other hand, pleads that there was corruption, I think there's a disconnect there where the ICSID arbitrators, whose main purpose is to promote investment, the investment climates, will likely ignore the corruption because its role is, the ad hoc tribunal would be biased towards promoting investment climate.
Okay, thank you, Attorney Bernas. Questions now from the court. Justice Corona.
We already ruled in Gingoyan that the just compensation to be paid to Piatto must be based on Republic Act 8974.
Yes, Your Honor.
Are you in effect asking us to reconsider this ruling?
If Your Honors, I do not mean to say, Your Honor, that if the expropriation were to proceed, the court must fashion out a different standard of compensation. What I'm saying, Your Honor, is if the expropriation were to proceed, then necessarily the standard found in the rule and in the law must be followed. What I'm saying, Your Honor, is that if Your Honors agree with me that expropriation is inappropriate for this particular case, then we would have to look at a different standard for compensation.
So in effect, you're asking us in a slightly different way to reconsider this ruling.
If Your Honors, my view, Your Honor,
What you cannot do directly, you're doing indirectly.
I wouldn't put it that way, Your Honor. If Your Honors agree with me that the issue of expropriation has not been precluded because it was not specifically stated as one of the issues in the decision. The decision in Gingoyan listed the issues that the court was going to tackle, and that was not one of them. So if Your Honors agree with me that I am not precluded from raising that issue, then yes, we can reopen the whether expropriation is valid. But if Your Honors, of course, disagree, then we're stuck with expropriation. And I'm afraid $1 billion.
Can you more or less give the court some ballpark figures on the difference in peso terms between the amount that can and should be paid under Republic Act 8974 and the amount that should be paid under quantum meruit?
Yes, Your Honor. Fortunately, Your Honor, that isn't going to be difficult.
Give us an idea. I know it's difficult.
Yeah,
but
well,
give
no,
us
it's
an
not
idea.
going to be difficult, Your Honor, because there are just two things. First, Your Honor, the terminal was contracted out under a turnkey contract, fixed price of $320 million. So there really isn't much else to talk about if we are talking about cost. And in my own observation, I understand that the building of terminals has now become standard. You can ask any general contractor how much it will cost, and he will just ask you how many passengers. And a terminal with 10 million passengers will cost $350 million. You can ask any international contractor, and he'll give you the same price. So fortunately, that's easy. The problem really is with the theory of just compensation. you're required to pay more than cost, because just compensation favors the expropriatee. He's entitled not just to cost, and Republic Act 8974 spells it out. It says replacement cost at current value, overhead, contractor's profit, attendant cost used in the installation and acquisition. All of that will be, and the claim of Piatto is that it cost them $500 million. The claim of Fraport is another $500 million. In between there are some of the soft costs that were mentioned in the newspaper, some that were mentioned here. All of that, Your Honors, do not directly go into construction, but they can be justified under profit, etc. In the Fraport case, Your Honor, may I point out that when the government filed its counter-memorial, I think on December 20, 2004, it denied that it was taking on expropriation. It hired the best international law experts, including Professor Brownlee, who stated in his opinion that the government was not liable for anything because no rights can arise out of an illegality. He also explained that the annulment of the contract was in the nature of a self-protection measure of the state and therefore not compensable. The unique aspect of this story, Your Honor, is that on the next day, and if you consider the time difference between Washington, D.C. and the Philippines, we're actually talking about the same day. On the same day, the government filed an expropriation case in Pasay. Now, it's been a few years past. Certainly, from taking an initial position that it was not expropriating, and then from later saying that it was expropriating, I do not think it would be inappropriate for the government to be imposed penalties by the ICSID for first denying that it was expropriating and then later saying flat out that it was expropriating. This is the problem, Your Honor. And my figures might be wild. You might say they might be wild. The difference is between $350 million and $1 billion. I may be off by $100 or $200 million. But that is still more than $350 million that the government never expected to spend. That really is the consequence of the government's decision to expropriate. I don't think we can ignore the international consequence, and I don't want to unduly alarm Your Honors. I will point out that there is a New York Convention of 1958 which permits a state to reject an arbitral award if the award is against public policy. But how are we going to do that, Your Honor, if the arbitral awards will be based on the fact that the government has stated that it has expropriated? In public international law, that would be considered as a declaration of state. And the affirmation of the state's judicial body of the legality of expropriation will be the authoritative basis for the ICSID to simply rule that an expropriation has taken place.
Just one last question. You stated in your pleadings that Piatto has not accepted the binding nature of the expropriation proceedings. Can you explain?
Yes, Your Honor. I think it was Justice Puno who asked whether Piatto should be made a party in this case. When the government filed this petition, the government stated that it was not impleading Piatto because it said that Piatto was not opposed to the position of government. I filed a manifestation stating that, in my view, Piatto was opposed to the government's position and that it was not the place of the Solicitor General to state what position Piatto had. But the fact of the matter is, Your Honor, Piatto has consistently stated that it had its reservations in the participation. Now, let me illustrate, Your Honor, how this is concretely taking place in the trial court. Under Republic Act 8974, the government is required upon expropriation to state the preferred value. And this is the 3 billion pesos that Your Honors permitted to be paid. The law also states that if the preferred value is not disputed, then that preferred value becomes the final value. Well, Piatto hasn't disputed it. What Piatto has done is stated that the court had no jurisdiction and that it should not take part in all that. But it has not stated that the preferred value is too low, we should be paid so much. That is because Piatto is preserving its claim in Singapore. And it has not taken any positive steps to ask for any reliefs. In fact, Your Honors, the 3 billion was not demanded by Piatto. Piatto did not even take a positive act to take the 3 billion pesos. Judge Mupas had to order Piatto to take the 3 billion. That's just so Piatto would be able to preserve its standing in the Singapore ICC arbitration.